Assalamualaikum and good day everyone. We are from Group 7 and today we will present about payment. For the definition, payment in general is the money given or to be given to a person or persons in return for the goods sold or services rendered. In construction, payment is defined as the consideration in terms of money for the work that a contractor has carried out in accordance with the contract plus the materials delivered to site. Contractually, the said money must be paid promptly or on time and fully unless there are specific reasons for delaying or withholding it. Payment are divided into two, which is interim payment and final payment. I will explain about interim payment. First of all, interim can be defined as temporary, provisional, or short-term. Definition of interim payments is provisional or short-term payments made progressively to a contractor at weekly, bi-weekly, or monthly intervals based on the value of work that the contractor has carried out. The payment is disbursed upon certification by architect, SO, engineer, or contract administrator. This certification is called interim certificate. Payment to contractor and interim certificate is mentioned in Clause 28 of PWD Form 203A. To summarize this clause, firstly, SO will make the first valuation when the contractor has executed the work. After that, SO will make valuation for progress usually once a month. And then, SO should issue an interim certificate stating the amount within 14 days from the valuation. The amount stated in interim certificate must be agreed between parties. However, this clause is not applied to any unfixed materials and goods which supplied by nominated supplier. For PAM 2018, it is mentioned in Clause 30. For Clause 30.1, it is stated that contractor shall submit payment application at the interim claim interval with complete details and particulars as required by the architect and QS. Architect shall issue interim certificate to the employer within 21 days after payment valuation from QS. Next, for Clause 30.2, it is stated that amount stated in interim certificate shall subject to agreement between parties. Certificate shall only include the value of materials and goods which are reasonably, properly, and not prematurely brought to the site. Reasonably and properly yang dimaksudkan di sini adalah barang-barang yang sampai di site perlulah barang-barang yang sudah sedia untuk digunakan. For Clause 30.3, architect shall not be entitled to revise or correct any payment certificate issued by him under the contract. But architect may make correction or modification by later certificate if there is any errors. This is the full Clause 28 from PWD Form 203A for your reference. And this is Clause 30 from PAM 2018 that mentions about certificates and payment. Next is fluctuation of price. Price fluctuations are upward or downward swings in the prices of products in an economy. Fluctuations in construction contracts provide a mechanism for dealing with the effects of inflation, which can be very significant on large projects. Fluctuation clauses in contracts may allow for changes in taxation, changes in the cost of labor, transport and materials, increases in head office or administrative costs, and generally, the contractor is not entitled to fluctuations after the completion date. Clause for fluctuation of price is only available in PWD form, which is mentioned in Clause 30. Clause 30 secara keseluruhannya menceritakan tentang amount yang perlu dibayar oleh kerajaan kepada kontraktor sekiranya berlaku fluctuation of price. Jumlah kontrak sum akan bertambah atau berkurang mengikut kepada perubahan harga semasa. Assalamualaikum, my name is Nur Afrina. The next topic will be about final account and payment certificate. Definition. In basic terms, a final account in construction contract is defined as the agreed statement of the amount of money to be paid at the end of a project contract by the employer to the contractor. In practice, the closing final account should be completed after the expiry of the defect liability period. These are the comparisons of the final accounts according to the forms of contract. Firstly, based on the PWD Form 203A revised 2010, Clause 31, it states that the contractor should submit full particulars complete with supporting documents within but not than 3 months after the issuance of the Certificate of Practical Completion. The Superintendent Officer SO shall issue the final certificate within 3 months after the expiry of the defect liability periods for the whole of the works or 3 months after the issue of the certificate of completion of making good defects. Secondly, based on the PAM Contract 2018, Clause 30.10, the contract states that the contractor shall send to the architect and the quantity surveyor all documents with supporting of the draft final statement within 6 months after practical completion of the works. As an addition, based on the FIDIC First Edition Red Book, Clause 14.11, the contract states that within 15 days after receiving the performance certification, the contractor should submit the draft of final statement with supporting documents, showing in detail in a form approved by the engineer. The final account is categorized as on time if it can be resolved within the time period specified in the forms of contract. The similarity between the forms of contract is the process of submitting the final payment claim after the certification of making good defect or defect liability certificate was issued. The process of final account involves 3 major activities. Stage 1, preparation of final account. Stage 2, submission of final account. And finally, Stage 3, certification of final account. It is important to follow the order of this final account process and to submit and return the relevant document reasonably on time to ensure the success of final account closing. Stage 1, preparation of final account. The preparation of the final account occurs throughout the contract period. Financial statement prepared by the QS will generally serve as the starting point for the final account discussion. Meetings usually will be held as one of the process of the preparation of the final account. It is an opportunity to exchange information and present methodologies for evaluation of each variation in accordance with the contract. Most of the preparatory work should have been carried out ahead of time so that the final account meeting can focus on agreeing the few outstanding items that may be still pending. Stage 2. Submission of final account. Upon the expiry of DLP and within the timescale prescribed in the contract, the contractor should submit the final account in the form of a final account statement with supporting documentation showing in detail the value in accordance with the contract of the work done in the contract, together with further sums which the contractor considers to be due to him under the contract, to effectively and efficiently facilitate subsequent agreement with the SO or QS of this submission. It is important that the respective detail and substantiation are provable, auditable, and justifiable in the accordance with the contract. Normally, project managers or QS will compare the original cost project with the actual plan once the resources for the performed schedule work are utilized. During this phase, there may be a need to adjust or justify what is necessary in order to keep the project on allocated budget. Stage 3. Certification of final account. SO or QS is responsible to issue a final payment certificate to the contractor within the timescale specified in the contract after receipt of the contractor's final account statement and of all information reasonably required for its verification. The final payment certificate will be issued when the final account is agreed. It is issued at the end of the DLP and has the effect of releasing all remaining money due to the contractor, including any remaining retention.
This is the example contents of final account. As you can see on the screen, there will be statement of final account, final work done for all of the works, summary and form of variation of the works, LA, CPC, and valuation for interim certificates. And this is the example statement of final account. Next, we'll be talking about financial statement. Definition. A financial statement is a periodic cost report which shows the financial status of a project at regular intervals during the construction stage. It gives necessary cost information to the employer, architect, and other relevant parties to enable the project team to control the cost of the project. QS regularly prepare financial statements in the form of a summary of the estimated final contract sum, taking into account the cost implication of issued variations, anticipated variations, possible claims for loss and expense, and where appropriate, fluctuation in the cost of labor and materials. In the preparation of financial statements, the QS should work closely with the architect and other consultants so that all the information that will affect the project cost is passed to the QS without delay and misunderstanding. The format of a financial statement is largely dependent upon the employer's requirements. This is the example of financial statement. Firstly, you will have to do the project details. Such information is important to avoid confusion with a periodic report which is prepared at regular intervals. Lastly, the content of financial statement also will have the schedule of progress payment.
Advance payment is defined when part of a contractual sum is paid in advance of the change, like pay before any work has been done or goods supply or before a contractually agreed upon due date. So the company sometimes made an advance payments to the supplier when their orders are burdensome to the producer. Put it another way, if the advance payment is not received, so the service will not be provided to the contractor. Next, we go through the special provisions to the condition of advance payment. Based on PWD Form 203A, Clause 69.1, the contractor is allowed to take advance payment in accordance with the terms set in the contract within 3 months of the date of possession of site. So they have the following conditions that contractor need to follow. So all three conditions is compulsory for advance payment and need to be submitted to the superintending officer or SO who manage the project. And the submission also must not more than 3 months after the date of possession of site or it will be rejected. If the client agrees to make an advance payment, he should require an advance payment bond as a secure to against default by the contractor. Jadi klien sepatutnya apabila dia dah bersetuju untuk melakukan advance payment to the contractor, jadi dia perlu mengambil advance payment bond sebagai kejaminan untuk diri dia. Advance payment bond ni dia sama dengan advance payment guarantee ataupun advance payment stage. Dia normally be on demand bond di mana bondsman membayar amount of money set out in the bond secepatnya or immediately without any preconditions having to be met. And this method or this advance payment bond dia berbeza sikit dengan conditional bonds di mana bondsman is liable if there has been a breach of contract that established. And conditional bonds ni selalunya issued by an insurance company and the payment conditional upon the client to provide the amount of loss which he has suffered. So, based on PWD Form 203A, Clause 69.3, liabilities under the advance guarantee will be terminated upon receipt by the government of the entire amount of advance paid. However, if the full amount of the advance payable cannot be realized before the contract expiry date or any further extension or contract case is determined before the date of determination, the advance payable to the government must be covered from the advance guarantee. So, on the left side is the example of advance payment guarantee. Next, there have a few reasons taking an advance payment bond. Means dia ada beberapa sebab kenapa klien perlu ambil advance payment bond setelah dia bersetuju untuk melakukan advance payment. First of all, advance payment bond can support payment to the contractors by the client in advance of work being done. Besides that, large costs are often incurred for contractors and the advance payment can be crucial to their cash flow and ability to execute the project. And lastly, the advance payment bond protects the client in the event that the contractor fails to meet its contractual obligation. Contohnya, contractor tu bankrupt. There have two benefits of advance payment bond. First, advance payment bond is an opportunity to the contractor to able pay the payment of cash to be made in advance work that carry out and provide by them. And it is also an opportunity to fabricate off-site if it is required and provides a level of comfort for bond recipients. So, we are done with advance payment. Now we go through to CIPAA. CIPAA actually a short form from Construction Industry Payment and Adjudication Act 2012, which is law enacted on April 15, 2014 by the Malaysian Parliament to resolve construction payment dispute and reduce cash flow in the construction industry through a statutory CIPAA court process. Typically, construction payment disputes are resolved by arbitration or a court action that is often time-consuming. And as a result, the contractor or consultant will lose the much-needed cash flow for a long time. CIPAA adjudication dah diguna oleh semua company kontraktor yang mempunyai masalah during the construction payment. And selalunya kalau guna court biasa, dia akan memakan masa yang lama, tapi dengan CIPAA dia memakan masa yang pendek saja dan tidak memerlukan banyak wang yang keluar. They have a few requirements that must be met under the CIPAA adjudication proceeding. Firstly, there must be a written contract. However, it cannot be mistaken for a formal comprehensive contract drafted by a lawyer. The formalization of the contract can come from a series of letters, correspondence, and may even include purchase orders and shipping orders. This is in line with guidelines issued by the CIPAA Administrative Centre. Secondly, the subject must be within the scope of the CIPAA, and the contract must be related to the construction work and the construction consultation services. The meaning of construction work under CIPAA Act, such as construction, extension, installation, repair, maintenance, renewal, removal, renovation, alteration, dismantling, or any types of demolition. These include any work that is an excluded part of or is in preparation for. The work including site clearing, soil investigation, improvement, land transfer, excavation, foundation laying, site restoration, and landscape. On the other hand, construction consultancy include planning and qualification studies, architectural work, engineering, service, exterior and interior decoration, landscape services and project management. Construction work and construction consultancy must be carried out within the country of Malaysia, either wholly or partly. And lastly, CIPAA does not apply to construction contracts signed by individuals for construction work that are less than 4-story and are fully intended for that individual's work. There have 9 types of claim. First, delayed payment, non-payment, non-certification or under-certification, deductions or set-off, variation order, loss and expense, retention sum, final account, professional or consultancy fee. This is CIPAA procedures. So, let's go through one by one. Step 1. Payment claim. It must be served by a non-payment party to a non-payment party under Section 5 of CIPAA. Step 2. Payment response. To be paid by the non-payment party to the unpaid party within 10 working days under Section 6 of the CIPAA. The payment responsibility must state the amount in question, either the total amount claimed or part thereof, and the reason for the dispute. Step 3. Notice of adjudication. After a limited time to file a payment response, the notice of adjudication may be filed in accordance with Section 8 of the CIPAA. Step 4. Appointment of adjudicator. The party has 10 working days under Section 21 CIPAA to agree to the appointment of an adjudicator. In the event of a failure by Section 23 CIPAA, any party may request the director to appoint an adjudicator. Upon request, the director shall appoint an advisor within 5 working days. Step 5. Terms of appointment. This matter can be negotiated and agreed to by the adjudicator within 10 working days of his or her appointment. However, if the adjudicator fails to receive its appointment within 10 working days, the adjudicator appointment process will resume. Step 6. Adjudication claim. Adjudication claims must be filed in accordance with Section 9 CIPAA together with all supporting documents within 10 working days of receiving an appointment by the adjudicator. The adjudication claim must be submitted to the respondent and the adjudicator. Step 7. Adjudication response. Adjudication response and all supporting documents must be submitted in accordance Section 10 CIPAA within 10 working days of receiving the adjudication claim. And Step 8. Adjudication reply. The claimant then reserves the right to respond to the adjudication response via the adjudication response within 5 working days of receiving the adjudication response based on Section 11 CIPAA. So guys, can we continue? Please, let's continue. Step 9. Representation. Section 8 CIPAA allows the parties to represent themselves or be represented by any representative including solicitor. Step 10. Adjudication proceedings. The adjudicator has powers under Section 25 CIPAA to conduct court proceedings as it deems fit. In most cases, the adjudicator will not allow oral hearing. And last step is decision. According to Section 12 CIPAA, the adjudication decision will be submitted within 45 working days of the date of receipt of the adjudication response, or from the date the adjudication response is due. There have 8 advantages of CIPAA procedures. First, speedy dispute resolution for the recovery of payment in the construction industry. Number 2, provides binding and enforceable decision on payment dispute. The adjudicator's decision can be enforced as judgment. Number 3, high level of enforcement. It allows suspension of works or reduced rate of progress. Number 4, enables claim direct payment from principal. Number 5, parties can choose their own adjudicator. Number 6, adjudicator has the relevant expertise in specific field. Number 7, it is informal procedures. Number 8, private and confidential. And last slide, it is about disadvantages of CIPAA procedures. Number 1, CIPAA 2012 only confines to payment dispute in relation to construction contracts falls under Section 4 of CIPAA 2012. Number 2, the decision made by the adjudicator is interim in nature as it is subjected to arbitration and litigation. Last but not least, the adjudicator will decide the course and direction of the proceedings. Parties has little room to negotiate. So that's all of our presentation for today. Thank you guys for lending your ears. Selamat Hari Raya from us, and stay safe and stay at home. Thank you. Bye-bye.